It is now my pleasure to turn to the next part of the programme, the opening dialogue of this evening, which includes three professors. And it is my pleasure to introduce the first professor, Professor Yasuaki Onuma, who's Professor Emeritus at the University of Tokyo. He has studied and taught in various universities and research institutions throughout the world, such as Harvard, Yale, Princeton, Cambridge, Paris, Peking, and the Max Planck Institute for Foreign and Comparative International Criminal Law in Freiburg. He has published widely and is an eminent scholar in Japan and known to many of you here in this room. Unfortunately, Professor Onuma is not able to be with us this evening for personal reasons, but we have been in touch over the last few months, and he has sent us a video message which he has asked us to screen at the beginning of this opening dialogue, after which I will invite the other two professors to join us on stage for a dialogue in person. So we'll roll the video. Thank you.
Good evening, distinguished colleagues, ladies and gentlemen. It is a great honor and truly a pleasure for me to participate in the conference through this video recording. I would like to express my sincere gratitude to the organizer, particularly Dr. Dietrich, Professor Cryer, Dr. Mimaki, and Mr. Takagi for making it possible. I'm going to address 4 groups of questions based on Professor Cryer's 10 questions. I believe you have a memo with the questions distributed by the Secretariat in advance. First, can we speak of a legacy of the Tokyo trial? The answer depends on how we understand the concept of legacy. On one hand, flaws are too apparent to allow to talk about only a positive legacy of the trial. In Japan, the reactionaries or revisionists have made full use of these flaws of the grand historical narratives of the majority to justify their argument, and succeeded in touching a chord of ordinary citizens. To this extent, the negative legacy of the trial is substantial or even huge. On the other hand, there are contributions of the Tokyo trial, particularly if seen from a perspective of history of humankind. I have regarded the educational effect of the trial on the Japanese citizens and world at large as most important. Tokyo trial, by taking the form of a trial, demonstrated atrocities and acts of aggression by Japanese military forces with the undeniable evidence of facts. Many scholars share this view. In addition, I believe the fact that Tokyo trial did not deny but confirmed the Nuremberg judgment is highly important. Suppose that Paul's opinion had prevailed and the judgment of the trial had been written according to his argument. Still, the Nuremberg principles would have had an impact on the post-war history. However, its authority would have been seriously undermined. We can talk about the so-called development of international criminal law based on the Nuremberg principles, precisely because the Tokyo trial endorsed or confirmed, but not denied, the judgment in Nuremberg. Second, should courts engage in writing grand historical narratives, as did the majority and PAL in Tokyo? The answer to this question should be definitely no, at least from a lawyer's perspective. The fact that the majority did write such a grand historical narratives has been abused by the revisionists to attack the judgment of the trial because flaws of the majority narratives is too apparent. However, this problem requires further analysis. I would assume neither the majority nor Powell thought they were engaged in writing grand historical narratives. They most likely considered that that was an important part of their reasoning needed to legitimate their judgment. Also, the historical narratives probably contributed to the educational effect of the Tokyo trial. The atrocities of Japanese military forces demonstrated in the trial were certainly shocking by themselves. However, without narratives, the fact of atrocities cannot have any meaning. Thus, elucidation of the historical facts was definitely necessary. So the problem lies in the quality of the elucidation adopted by the majority and Judge Powell. In this respect, there is little doubt that both were seriously flawed. The majority relied excessively on the extended use of the concept of conspiracy to explain the historical development of Japanese aggressions from 1928 to 45. Powell's view is stimulating if read as an academic writing. However, it was certainly one-sided, almost justifying Japanese aggressive wars as wars of liberation against European colonial rule. Even worse, he wrote it as a judge by absenting himself from the proceedings of the trial for many, many times. This is totally inexcusable. Third, about the issues passed over in the trial. This question includes another question. To what extent was gender sidelined in the Tokyo trial, and if so, why? It is clear that the problem of gender was sidelined in the trial. It was mainly because at that time, few people are aware of the problem itself. For example, the Universal Declaration on Human Rights, adopted in the same year of the judgment, is also insufficient in the treatment of gender. Not only the trial, but subsequent studies on the trial did not pay sufficient attention to the problem of gender until early 1990s, when people became sensitive to it. In addition to gender, I've been arguing that the emperor, Japanese people, and Asia were absent in the figurative sense, or ignored or sidelined in the Tokyo trial. As to the emperor, his absence clearly revealed the political nature of the trial, which was conducted within the framework of US occupation policies. As to the Japanese people, their absence was in a sense natural because the Tokyo trial judged only leaders of Japan. Yet, this had a serious negative effect on the awareness of war guilt among Japanese people. They already held a strong sense of victimization caused by a large-scale strategic bombing by the United States, treachery military attack by the Soviet Union in violation of the Neutrality Pact between Japan and the Soviet, and above all, atomic bombing on Hiroshima and Nagasaki. Concentrating war guilt on the leaders in the Tokyo trial reinforced their sense of victimization. This sense of victimization was further strengthened by the assertion of post-war Japanese intellectuals and Chinese leaders that only the Japanese militarist leaders were responsible for the war, and that Japanese people, together with the Chinese people, were victims of the war. When I argued in 1983 that not only the Japanese leaders, but Japanese people as a whole were responsible vis-à-vis Asian and other peoples who are the victims of Japanese aggressive wars, I was either criticized or ignored by mainstream historians. My view gradually prevailed among intellectuals and media, but it took much time. As to the problem of absence of Asia, I will argue in the following section. Now finally, I should talk about the task for the future. This final section is concerned with 4 questions that Professor raised. I believe you have these 4 questions on the memo, which was already distributed. First, let me talk about the task of scholars. From the very early days of my studies on the Tokyo trial and its related subjects, the concept of crimes against peace and Japanese war guilt, I have always argued that an interdisciplinary study is necessary because Tokyo trial has so many aspects: legal, political, historical, sociological, cultural, and philosophical. You may be a lawyer, historian, or political scientist, but you must have a sufficient understanding of neighboring disciplines. I myself have been engaged in the interdisciplinary approach since I published Sensou Sekinin Ron Josetsu, or Prolegomena to the Responsibility for War, in 1975. Here's this book. Future scholars must make really serious efforts to carry out interdisciplinary studies. To engage in the interdisciplinary study is not an easy task. You must be well prepared for it. Finally, I must respond to Professor Creyer's final question. How should we read the Tokyo trial from my trans or intercivilizational approach? The answer to this question is closely related to Professor Creyer's another question. What explains the comparative lack of knowledge of the Tokyo trial in the Western world? There are many factors causing the comparative lack of knowledge of the Tokyo trial. The fact Nuremberg was the first international war crimes trial and Tokyo was the second is one factor. The comparative high quality of the judges and prosecutors in Nuremberg, symbolized by Jackson versus Keenan in Tokyo, is another factor. However, the most important answer to this question is because the fundamental framework within which we live today, or since the end of Second World War, is constructed as West-centric. See, for example, the global discursive space. While CNN, BBC, and New York Times have tremendous impact on how we see the world, NHK and Asahi newspaper have not. While the voice of a Harvard professor may be globally heard, that of Tokyo University professor is not. This is the world we take for granted since the 19th century, when European powers established hegemony over the world and the US inherited it. When I organized an international symposium in 1983, inviting late Judge Rowling and others, I challenged such a West-centric or US-centric perspective by deliberately introducing Asian perspectives. This book, The Tokyo War Crimes Trial, an international symposium, is a result of this symposium. I invited Chinese, Korean, and Burmese scholars and emphasized the importance of grasping the Tokyo trial not only through the lens of the United States, but also that of Asians victimized by Japanese aggressions. From an academic perspective, my efforts bore fruit in Japan. Although some hold my view on the absence of Asia in the Tokyo trial as incorrect, arguing that the trial addressed the issue of Japanese atrocities in Asia, most intellectuals have accepted my view. As to the criticism, I think it is completely off the point. I have never argued that Tokyo trial did not address the issue of atrocities against Asians or aggressive wars against Asian nations. What I have been arguing is the ignorance over overlooking Asian perspectives in the Tokyo trial and studies on it up to early 1980s. What is needed is to liberate ourselves from West-centric perspective prevalent in today's world. This is an extremely important yet difficult task, for we have been so accustomed to seeing the world from this prevalent West-centric perspective. Those who are interested in this issue, please read my International Law in a Trans-Civilizational World, published by Cambridge University Press last year. Here's this book, International Law in a Trans-Civilizational World. Because Asian nations, represented by China, are catching up with Western powers, we may be able to see the world from a richer, more well-balanced trans-civilizational perspective in the long run. But given the regrettable soft power situation of contemporary China, it takes a tremendous amount of time to reach that stage. However, we should not be too pessimistic. In human affairs, good travels at snail's pace. With this wisdom, which I learned from Mahatma Gandhi, I conclude my presentation. Thank you very much for your kind attention. Arigato and vielen Dank.
Well, once again, thank you to Professor Onuma for sending this video message and thus participating in the conference. I'd now like to invite Professor Robert Cryer and Professor Urs Matthias Sackmann to take the stage and to join us for a live opening dialogue, deepening some of the questions by Professor Onuma. Professor Robert Cryer is Professor of International and Criminal Law at the University of Birmingham, and Professor Urs Matthias Sackmann is Professor of Modern Japanese History and Culture at the Freie Universität Berlin. And the floor is yours. We look forward to your dialogue. Thank you.
Okay. The reason for that being, when Professor Boyster and I wrote our book, his daughters were approximately 8 and 10, and being boisters, they were boisterous. And if we needed 90 minutes of peace and quiet, High School Musical did the trick. I'd also like to thank Professor Onuma for his serious efforts to make sure that he was able to give us his insight. On the basis of some questions that I submitted to him, I'm not sure if you actually have them all, so we'll go through them as we go along, and I'll make sure that we cover the specific questions, so also it contextualizes Professor Onuma's remarks. Just as a final thing before we go straight in, for me, it was law or rock and roll at the age of 17, and I chose law, bourgeois that I am. But the bands I used to go and see would always say one thing at the beginning, and I mean this genuinely: your stage is our stage is your stage. If you've got questions you want to ask, then ask them, because we'd love to just talk about them, because this should be about inclusionary discussion and debate, not two blokes shouting at one another. And with that, perhaps I can start off. And the very first question which we asked Professor Onuma was, given the fact that we had all these various different opinions, which Professor Totani mentioned, can we speak of a singular legacy of the Tokyo trial?
And yeah, so what would be the legacy? I mean, this is already just the beginning of the conference, and in the end, we will come back to this question: what is the enduring legacy of the Tokyo trial? And Professor Onuma first came up with a negative statement that, well, this, due to its flaws, the legal legacy is probably diminutive. You can speak to this better than I do. But from a historian's perspective, and from also an intellectual, particularly an intellectual historian's perspective, I find fascinating to see the Tokyo trial as basically as a textbook model of the polyphony and the multi-perspectivity of international legal discourse and of historical discourse. That there are so many positions involved in the Tokyo trial: naturalists and positivists, and of all kinds of breeds and schools, and you can decipher where they come from and why they argue the way they argue. And the same goes for the historical point of view, that there are so many ways to look at history. Well, the natural tension between coming to a definitive judgment and the ambivalence of looking at history.
I mean, I actually think in terms of the legal legacy, there is again this polyphony. Insofar as if you look at the judgment of the majority, which basically just says, we agree with Nuremberg, we're not going to add to it, we're not going to try and set out any new ground, even though, as Professor Totani alluded to, the movement to command responsibility in relation to government officials who were not necessarily military. And bear in mind that this is not that long after the Yamashita case, where command responsibility was practically speaking invented. To expand it out to governmental officials in the manner in which they did was quite big. But generally speaking, and they specifically said it in the majority opinion, we're not going to disagree with Nuremberg. And it has to be said that there is no question that it was pressure put on the judges to say precisely that.
Yes, but you know, historically speaking, was there any way that judges could actually, I mean, that the judgment could have gone a different way than Nuremberg?
Well, Judge Powell would have said precisely so. I mean, Judge Bernard based himself entirely on natural law. Webb,
yes, but then he was the minority for a good reason.
Röhrling also based himself on different reasons, and both Röhrling in the wonderful interviews he did with Antonio Cassese actually expressly said that the Dutch government pressurized him to agree with Nuremberg because they didn't want to undermine the notional precedent. And he actually based himself on something entirely different. He said crimes against peace were retroactively created. Kirsten Sellers has identified pressure that was put on Lord Patrick, the British judge, to agree with Nuremberg, because at that point, a number of the Allied governments were really concerned that it could go the other way and retrospectively cast doubt on Nuremberg. And of course, Judge Powell very much decided to do precisely that.
But given the polyphony, I mean, there was also this talk about the legacy now, the educational effect as a legacy. That, of course, diminishes somewhat the educational merit of it, doesn't it?
I think it may have done at the time in an era in which history was considered essentially in a far more positivistic fashion, that the idea you could write a history rather than there were different histories. And to me, one of the legacies now, though, is that they had different opinions, is that there were different interpretations of events that were actually largely not contested. Professor Totani and I were discussing this because in an example of what is quite clearly, if one were a conspiracy theorist, an example of passenger profiling, of all the planes in all the world coming to Nuremberg today, and all the seats in all the planes in all the world coming to Nuremberg today, Professor Totani and I ended up sitting next to one another. In many ways, the prosecution and the defense did not fundamentally disagree on the facts. They disagreed on the interpretation of the facts and the intention of the actors. Nobody denied the invasion of Manchuria. What they disagreed upon was the question of whether it was aggressive or simply pursuant to a request from the notional Chinese authorities who've been imposed by Japan. But and so what we get, perhaps in a more modern, and you're a historian, I'm a lawyer, so you know better about this than I, is that even where there is a practically uncontested factual base, which for many of the actions, not all, but many of them, the question lies in the interpretation and the intentions of the actors.
And yes, and there, as a historian, of course, again, I have to say, I mean, as I told you, the truth of history lies in the sources of the beholder. It, of course, depends on what sources you adduce, and then, as Hayden White also said, there is a certain kind of meta-history. You do have certain kinds of Weltanschauungen, which you infer into what you write. This brings us to the question whether it was necessary of the judges to write grand history. And Professor Onuma denied, and I would say rightly so, because that the Tokyo trial is a typical example of, well, you could call it judicial hubris or overreaching, and thereby opening yourself up to a lot of criticism from revisionists as it happened. So it would have benefited the trial a lot if it had been a bit more disciplined about its historical remit.
I mean, one of the things about this which I'd be interested to hear about is, number one, should they have bothered with crimes against peace at all? Because at some level, to deal with conspiracy and crimes against peace, You are going to have to write a meta-narrative. And this was something that was accepted, for example, as far back as 1919 in the Inter-Allied Commission on the Responsibility of the Authors of the War. But also, so can it be done? Can you do crimes against peace without some form of grand narrative? Secondly, would it have been better just to drop the crimes against peace completely and concentrate on war crimes and crimes against humanity? And if they had done so, would the legacy have been better? And did the crimes against peace charge and the way they interpreted history as a result of that, do you think it diluted some of the very important findings about war criminality in particular? And it has to be said, Judge Powell may have provided a plausible counter-narrative in his dissenting opinion, but his discussion of war crimes in his judgment is disgraceful. It is what we would call in the European sphere denialism.
Yes, undoubtedly so. Well, these are very hard questions. And you pose these to me. And they are counterfactual questions, so historians don't deal in counterfactuals. What would have happened? It is also, well, I mean, it also depends on how far back do you go in history. I mean, we have heard in the opening addresses a number of commemorative dates, and one of the another commemorative date is 150 years of the Meiji Restoration, and when modern Japan began, and some people then start going back to that seminal event and say this is where everything started, where we were being in the danger of being colonized, and we had to defend ourselves, and we had to radically modernize, and in this modernization we may have overshot the goal a little bit, but that was basically the Western powers' fault, and so on and so forth. So.
I mean, we see that in all historical debates, don't we? I mean, for example, it's a cliche because there is truth in it that in the Balkans, if you ask about the bases of the Yugoslav wars of dissolution, quite often you'll end up in a discussion about the Battle of the Blackbirds in 1383.
Well, but in Japanese discourse, it is still not negligible. I mean, the address, the government address on August 15 in 2015, basically went back to the seminal event and started to tell the story from then. So it's still. Well, should the Tokyo trial not have focused on crimes against peace? That would have been a pity, though, because then we would not have the development or we would not have it now as it is, probably.
Well, again, it's counterfactual. So, I mean, because we already had Nuremberg, and one at least argument that
But Nuremberg focused more on crimes against humanity.
No, it was based around crimes against peace. It's been reformulated. Professor Burghardt, who I don't know if she's here, she very kindly shared me a paper that she wrote, and she makes very clear that actually the primary focus of the Nuremberg trial was crimes against peace. Now, when we look back on it, we look at it as a trial of crimes against humanity. But comparatively within the judgments and within the bases of the prosecution's submissions, crimes against peace were meant to be the primary focus of the trial. And the historical narrative, which is engaged in the Nuremberg judgment, is actually primarily about the invasions. The amount of discussion of crimes against humanity and war crimes is actually relatively limited. Not that it's not convincing, it certainly is. And they just say, the evidence is so overwhelming, we're not going to bother discussing it, essentially, because it's just so clear. Which it was, but actually the primary focus.
Right, but then so if they're considering this, how would you say, this commonality of the Nuremberg and of the focus of the Nuremberg and the Tokyo trial, the aftermath, the reception of it, and the great divergence which occurred is quite interesting. And that is often being compared. But lest we idealize the reception of the Nuremberg trial, I just might point out that actually the Tokyo trial was, in the Japanese public, was more positively received in the beginning, as in Germany, the Nuremberg trial, at least among lawyers.
Certainly the early reception of Nuremberg in Germany, from what I've read, is that it was not immediately fated by any stretch of the imagination. It was really a generational change that led to this rethinking.
It was, yes, both in the 60s, I imagine that there was a sharp uptick for the Nuremberg and a sharp downturn for the Tokyo trial in the reception in the
relative
German
societies,
in the relative societies, yes.
But do you think also, though, that the undoubted flaws in the Tokyo process undermined its claim to legitimacy or its appeal to history? And did the flaws, which there were, although perhaps they're overstated, just allow those that wanted to reject the tribunal? They gave them a hook to hang their critiques on. Because if you don't like the idea, you can criticize the process.
Well, in Japan, without doubt, but that was, as I said, probably only in a later generation. In the beginning, it was my contention is that in the beginning, the understanding of the Tokyo trial was very political from the Japanese audience, as far as it was concerned with it at all. I mean, many people just didn't care.
Well, too many people were actually, of course, busy getting on with desperately trying to go about their daily lives.
But even people who had a stake in it, I mean, I just recently read a diary of a person who was close to Konoe Fumimaro Yabeteji, and he was he worked as an advisor to the Japanese government in the Tokyo trial preparations, and he doesn't, in the end, he doesn't really care a lot about the judgment per se, and he's being given a ticket, to go into the Tokyo trial and see it live, but he doesn't go. So it's kind of, there's a certain kind of distance towards it, which I find very interesting as such. And then, of course, later on, the flaws are being exploited by revisionists in a very, how would you say, disingenuous way, I find.
As I say, I think part of it is that the flaws are overstated. Because there were flaws. I mean, nobody's going to claim that Webb was the greatest president that there's ever been of an International Criminal Tribunal. We have one here. So.
Keenan, the best prosecutor.
Well, I mean, Keenan, he was taken to Tokyo to get him out of Washington. He was taken back to Washington to dry out for 8 months. That's not me being deliberately provocative. This is abundantly clear. Quite frequently, he had to be kept away from the courtroom after lunch because he was incapable. It was once said of Keenan that he couldn't tell the difference between black and white unless it was on a label. And obviously, fortunately, you can't libel the dead, but actually, I think the defense of justification might apply there anyway. And I do think it's interesting that the prosecuting nations in Nuremberg, they sent their A game. If you want a prosecutor, okay, send a Supreme Court justice. If you want a prosecutor in Tokyo, you send somebody who is barely capable at best and you just want out of the way. Because his nickname was Joe with the Key Keenan, because he would always try and be a mover and player in Washington, and they were sick of him.
And how do you explain this stark difference in personal and quality of The attention.
I think, in part, there was a Eurocentric aspect. Secondly, by the time they were appointing people to Tokyo, the war was over. And particularly with the European nations, people didn't want to leave home and go away from their families again. And so the very best people said, you know what? I'm staying at home. I've spent 5 years away from my family. What's the deal here? You know, it's like, well, we'll go, you've got to go to Tokyo, be away from your family. By the way, no family is allowed to join them in Tokyo. How long is it going to take? We'll see.
But I think there's also a pattern to this. I mean, if you view the Tokyo trial also in the general context of how the U.S. occupation was conducted, or how, for example, the United States engaged in Japan, I think there's a certain kind of neglect or underestimation. I mean, it's also telling effect that, for example, German occupation was done and administration was done directly. The Western powers engaged directly, and the Japanese in Japan it was not the case. It was indirect occupation. It was kind of hands off. We don't want to bother, and we don't want to expend much more money and people on it, and that's also why we don't indict or even invite the emperor as a witness, because we don't want the hassle. So there was this kind of low budget, kind of Tokyo trial was the low budget trial.
Justice Röhrling described it, I think, quite beautifully again in these lectures or these interviews he gave with Kasese, and he cited Time magazine, who said the Tokyo trial looked like a second string road company version of the Nuremberg show.
Well.
But this does actually lead me on to perhaps some of the other questions. Firstly, obviously, the emperor, but what else was passed over in the Tokyo IMT?
Japanese people and their culpability by, of course, excusing the emperor as the new figurehead of the old and new symbolic figurehead of the state by the new constitution. And so, and as Professor Onuma rightly has observed, Asia, in the sense that, of course, there was an overemphasis on US-American casualties and not so much on the Asian casualties.
Yeah, I mean, I agree entirely. I mean, if you look at the sections on war crimes, it's extraordinary how detailed the discussion is on crimes committed, for example, on the Burma-Siam Railway against Allied prisoners of war. And then at the end, there's this little tag-on sentence that says, oh yes, 200,000 local people also died. As if this was an add-on to the undoubted depredations which were committed against Allied nationals.
But then realistically speaking, I mean, this victimized view of the Tokyo trial from the Japanese perspective is then very contradictory, because Japanese people were let off extremely lightly, not even reparations due to the San Francisco Peace Treaty. So the victim perspective, which Professor Onuma has mentioned, is very, very strange in that sense.
I mean, one thing that I'd be interested to hear your views on. If Unit 731, the Japanese biological and chemical weapons unit that acted in China, if its victims were European, do you think that it would have been indicted before the Tokyo IMT? I know it's a counterfactual again, but
they were indicted by Russians in the Khabarovsk trial.
which we'll be hearing about tomorrow, but I mean, that was in 1950. Once they had been whisked off to Russia, they'd found out what they knew and they found their results out, and then they prosecuted them. The difference being that the Americans whisked off the other half of Unit 731 and gave them research positions in universities.
Well, that's another grave omission, of course, yes.
I don't want to keep everybody too long because it is getting on a little. Why do you think it's taken so long, then, for the Tokyo IMT, at least in the West, to be considered of interest and importance?
Well, firstly, there is always the comparison with the Nuremberg trial, which sends a much clearer message, and the Tokyo trial has a mixed message, which is not so relatable. Then there are the exigencies of the Cold War, which put a blanket on everything. And the fact that also, as Professor Totani has mentioned, that research on the Tokyo trial has experienced a renaissance in the past 2 decades, or 2 or 3 decades, is also due to the fact that the Cold War has thawed and ended, and then Japan was finally also confronted with its victims, and that led to these whole historical disputes and all the things we know, the Yasuaki dispute and the textbook and so on and so forth, which also then renewed interest in history.
I mean, obviously, I'm from a country in which to describe something as an academic question is considered pejorative, but I'm an academic. So, do you think it tells us something about the level of interest which occurs because of the production of knowledge? People not doing Tokyo for a long time because there wasn't work on Tokyo.
Not accessible work.
Yeah.
There was.
Yes, I mean.
Apparently.
In English, I mean. It was certainly.
What is your?
Personally, I think part of it was the reason I wrote the book I did, and it's not all about me, I hasten to add, was when I was a PhD student, I read everything I could about Nuremberg. And there's some brilliant literature on Nuremberg. You know, Telford Taylor's The Anatomy of the Nuremberg Trials is an outstanding piece of work. And I went to read what there was on Tokyo. And frankly speaking, there wasn't much of it. And much of what there wasn't that great. The major monograph in English on the Tokyo trial was Mynheer's Victor's Justice, which was essentially Pal's dissent rendered into narrative form.
I really can't answer.
I do like asking unanswerable questions.
It is very difficult to, but I would say that the atmosphere of the Cold War and the political agenda was the decisive factor why Tokyo trial was not studied as it was. That, from a historian's perspective, that is my interpretation. From a lawyer's perspective, that may not be hold valid, but yeah.
I know we've run a little over time, so perhaps just to round up, why don't we take one question from the floor and see what people would like to ask? Or do people think that the drinks in the room next door are really quite tempting? Yep.
By elephant, I mean the attacks on Hiroshima and Nagasaki. How did all that become invisible?
Well, I think in many ways it's the classic reason that Tukokwe was deliberately excluded by the Allies as a legal defence, and any evidence on point was simply deemed to be inadmissible. Of course, the Hiroshima and Nagasaki attacks weren't entirely invisible in the Tokyo trial, because we had Pal's dissent, where part of his dissent was he said whatever we may lay at the feet of the defendants before us, and he obviously said, no, you can't lay any of it at their feet anyway. He said, there's nothing like Hiroshima and Nagasaki. It's also actually present in Judge Jaranilla's concurring opinion, where it's quite clear he had seen Powell's dissent in draft, because there's some quite ad hominem attacks, really, on Judge Powell. But he also said the Hiroshima and Nagasaki attacks were completely justified to the end of the war. Now, I'm not saying who's right, who's wrong. I have my personal views on points, and I think they were wrong. But they weren't completely absent. But it was this whole thing with the tu quoque, and it was the same in Nuremberg, actually, that any evidence of Allied crimes were largely excluded from evidence because, oh, this is irrelevant, we're prosecuting these, with one exception, which was the waging of unrestricted submarine warfare in the Pacific sphere, where Otto Kranzbühler, Admiral Donitz's defense lawyer, very cleverly got Chester Nimitz, the commander of the American fleet in the Pacific, to write an answer to an interrogatory question, which was, did the United States wage unrestricted submarine warfare in the Pacific? To which Nimitz wrote back and said yes. And so Kranzbühler said, I want to introduce this into evidence, not as tu quoque, but simply it could not be the case that the Allies would violate international law. Therefore, if unrestricted submarine warfare was undertaken by the Allies, it must be that customary international law permitted unrestricted submarine warfare. The result of that was the US Judge Biddle, threatened to dissent if if Dönitz was convicted and sentenced on that basis. The other judges, as a matter of compromise, said, look, we're going to convict him, but you can write the part of the judgment that deals with unrestricted submarine warfare, and we won't sentence him on the basis of engaging in submarine warfare.
Also, it should be mentioned that there was also blanket censorship on the bomb in occupational Japan during US occupation. So it, being a public trial, this was also probably a factor. But the Tokyo, it was later on there was a trial brought to the Tokyo District Court.
Shimoda and the
Shimoda case, in which it was decided, in which the decision was about the legality of dropping the bombs on Hiroshima and Nagasaki with the expected outcome. But it was not. That was later, after US occupation ended.
Thank you.
Thank you very much.